So do type into the chat box if you want to say hello to each other.
It's nice to see that there's people behind their black screens on the chat. So welcome, lovely to have you here.
Absolutely. So welcome, Bex. No, I understand that, Kate. I sometimes have those problems. So yes, sometimes keeping your video off does give you a slightly improved signal, I think.
Not very pleasant though if you're presenting to a load of black screens. So
No. I know. Sometimes I wonder. Yes.
Is the nature of this new technology? Well, not new now, but yes, we're getting. It's a different way of presenting, isn't it? To a whole screen of nobody. Talk to yourself for a while.
It has a nice air of informality though. I think I feel like I get to know people a little bit better sometimes. Oh no, we experience that everywhere, Leslie. Even in central London, I can never believe when I'm in central London Bridge, that I have the most appalling signal. I don't know whether anyone's experienced that in London Bridge, but good evening to Jude. Welcome. So we've got 45 people joining us at the moment. So we are expecting a few more, quite a few more. As I say, we'll be starting just in a few moments. So welcome to you all. Looking forward to getting started. As I say, do use the chat box as we go through the session. So I'm going to be keeping an eye on the chat box for any questions that you might have. Welcome to those just joining us. Thank you, Sarah. Sarah says she's got wet hair, so she's keeping her video off. Yeah, good idea. Good idea. Okay, so lots of people arriving now. Welcome to you. Good to see you. Hello, Sarah. A few Sarahs, actually. I need to remember if I'm responding to the right Sarah as we go forth. Hello, Heather and Ali. Good to see you. So for those joining us now, we're going to start in just a moment, just waiting for a few others to join us, and then we will make a start. So thank you very much for joining us this evening. We're looking forward to getting started. Oh, evening to Tiffany and Hannah. Good to see you joining us. And Amanda too. We have 67, 68 with us this evening so far. So good to see you all online this evening. As I say, do use the text box to chat to each other. Hello, Sophie. Evening to Sophie. And Chris. Good to see you this evening. Welcome. And welcome to Etz. Etz is one of my students. I know Etz. In fact, we've got a few of my students here this evening. So welcome to all from the University of Suffolk this evening. And Hannah and Megan, welcome. Okay, we're going to get started in just one moment. Just waiting for a few more people to join us. expect it's difficult when you're logging on at 6 to get on immediately with all of the others who are rushing in there. So welcome to Lauren and Emma and Emma, 2 Emmas joining at the same time. Okay, folks, so I think what we'll do is make a start. So I'd just like to introduce myself. My name's Kay Maddox-Daines. I'm from the University of Suffolk, and usually this event takes place at the University of Suffolk. Sadly, this year, we're not able to do it on campus, but we have the next best thing. We're doing online. So I'm delighted that we are still able to run the session. We have a number of people joining us, over 100 people joining us this evening, and we would appreciate it if you could perhaps keep yourself on mute throughout. And also, if you could please use the chat box for questions as we go. So I'm going to be keeping an eye on the chat box and summarising the questions at the end of the session. So the session probably will last around an hour, and then we'll have time for questions after that. So as you think about the questions, please do type them in, and we will try to respond to as many as possible. So I'm delighted to welcome this evening Sonia O'Reilly from Burkitt's, who has actually been running these sessions now, I understand, for 5 years. So we're absolutely delighted to have Sonia with us this evening. And Sonia's been working incredibly hard today to make sure that she's providing us with the most up-to-date information. But of course, it's not just about the current situation. This is an employment law update which covers the whole of the year. So perhaps when you're thinking about the questions, that they may not all relate to the current situation. They may consider perhaps other areas that you're working in too. So without further ado, let me pass over to Sonia, who's going to upload her slides. And as I say, please do type your questions into the chat box, and we'll keep an eye on that as we go so that we can respond to those at the end of the session. So over to you, Sonia.
Hello, everybody. Thank you for joining us this evening. It's really lovely that so many of you have logged on this evening after busy days that you've no doubt had. So welcome. And it's a great, I have really pleasure in having this opportunity to take you through this annual update again this year. So let me share my screen, and please do shout if it turns out that you can't actually see the slides when I've shared them. Can everybody see my slides on my screen?
I can see them. I can see them, Sonia.
You can. Super. So let's get stuck in to this update for this evening. Now, the first thing to say, just as Kay mentioned, I think it's quite important that we remember that this is an annual update. So whilst, of course, our minds are taken over by all things COVID related at the moment, and I will be covering points to do with the furlough scheme and the announcements that Rishi Sunak has made today. But I'm equally really keen to share with you the things that I think are really important for you as HR practitioners to be aware of that have come about in this last year since our update in October of last year. So these are the points that you can see in front of you that we're going to be covering. Actually, a point about the slides that I've sent round to you, or had sent round to you today, for you to be able to print off or scribble on as you saw fit. Those slides were prepared with the best of intentions minutes before, as it turned out, Rishi Sunak took to the floor in the House of Commons. So there are going to be a couple of changes that you'll need to note as we go through, but I'll highlight those for you as we go along. So the slides you'll see on my screen or on your screens in front of you that I'm sharing are the most up-to-date ones, which we'll make sure you can have a copy of after today as well. So we're going to look at the Good Work Plan, first of all. Then I'm going to talk about some cases and some recent decisions around the never-ending issue of employment status. We're going to look at employee data and monitoring, sickness, absence and disability cases, some points around redundancy, which I think are particularly topical, sadly, at this point in time. Then we're going to look at the job retention scheme and the job support scheme, public sector exit pay, some points that I just want to draw to your attention about the tribunal rules and procedures that have changed through this particular pandemic period, and also then some final cases on disciplinary issues, which have particular practical application, I think, so hopefully they will be useful for you. So as you can see, we've got our work cut out for us this evening, so I'm going to crack on then with looking at the Good Work Plan. Now, as you all recall, this was originally published back in December of 2018 as a plan of works to bring new employment laws and measures into place. Of course, some of those measures have come into place and some have been very much delayed, not least by Brexit when we were talking about this matter in the previous years, but now, of course, by COVID as well. But these are the points that have come into force, and they came into force, one of them, of course, in April last year, but I think it's still important to raise it. As you'll see there, the increased penalty for aggravated breach of employment laws. So that's an increased element of compensation that the Employment Tribunal is able to award, which has now increased from £5,000 to £20,000 on top of ordinary compensation that might otherwise be awarded. Then you'll see the other points there. I'm not going to take you through every single one of them, but you will see those other points that have come in this year. So since our last update on the 6th of April, particularly important, I think, to be aware of. I hope that you have already got the message that all workers, not just employees, are entitled to a written statement of their terms and conditions from day one. From the 6th of April, and that those terms now include certain things that were not previously in the Section 1 statement of terms that needed to be included, such as probationary periods information, information about right to paid time off, and benefits and training requirements. Those things now ought to be being provided on day one for people. So if you haven't got a grip on that yet, then that is something that does need to be dealt with. And the other points there, as I say, they are in force, and I don't plan on taking them through them in any particular detail, as they are now things which hopefully you are aware of. There are still some matters, however, that we are still waiting for. So again, I just wanted to raise those to your attention. These, again, coming from the Good Work Plan and things that were intended to be brought into effect by now, we would have thought, but of course now delayed. Some of them are really quite critical matters that we as employment lawyers felt would be really very useful to see enacted. So particularly, if you remember, the whole point of the Good Work Plan was looking at the gig economy. It all came out of the Taylor report and the review of that sector of the workforce, which is working on a much more casual basis. So particularly points around 0 hours workers and having some enhanced protections and enhanced rights for 0 hours workers is still something that we don't have any further guidance on or any further legislation planned. It is still intended to be included in the employment bill when that comes out, but my goodness, at the moment we have no idea as to when that would be. Consultation closed in 2019 on this point about 0 hours workers, but it's still out for discussion. I would say that particularly at the moment through this pandemic, of course, what we're seeing is substantial numbers of those sorts of employees or workers who might be on 0 hours contracts, finding their employment arrangements to be very much in jeopardy. I think they're a group which are particularly impacted by the current virus. So they are a group which I hope will see more protection in due course. Then the other points up there, again, I'm not proposing to go through those in detail, but you have them then in your slides to see the things that should be coming in force in due course or at some point in the future. There was an employment bill that was proposed in the Queen's speech in December of last year. We now think that it's rumoured we won't see anything before the mid 2021, but of course I expect that bill will be pushed back and back in the current situation. And those points that you see on the slide in front of you are the other particularly key areas which the employment bill, was supposed to be looking at. A couple of things that I just wanted to highlight: neonatal leave and pay. So that is expected to come in 2023, but that's not confirmed. The consultation was published in March of this year on that particular point, and it was to give an additional week of leave for every week that a parent has a child in neonatal care, to be taken at the end of any period of maternity or paternity leave. So that's something that might well be enforced, but not for some time. And the same with carers leave. That was to be an additional 1 week unpaid leave for somebody with caring responsibilities. Consultation on that particular point closed on the 3rd of August this year. So it was still rumbling along and still being dealt with despite the pandemic, but there's no confirmed timetable for that either. Couple of points where we do have some rights that have come into force, just worth noting. The parental bereavement leave regulations have come into effect on the 6th of April, which brings up to 2 weeks leave for somebody paid at the statutory rate of pay for leave where somebody has lost a child under the age of 18, or where they have sadly suffered a stillbirth after 24 weeks of pregnancy. And it's a day one right for a parent in those situations. Now, again, one would hope this is a safety net, where one would hope that most employers would be more generous in these sorts of situations, but it provides that safety net. Also in force from April this year was the slightly changed provisions around the taxation of termination payments, which is worth being aware of. I hope you are aware of this and have been alive to it for any termination payments that you might have made. This goes along with HMRC's attempts to really tighten the requirements and the regulations around termination payments. Particularly, they were looking at payments in lieu of notice previously, but termination payments in excess of £30,000 are now subject to national insurance contributions, employer national insurance. That's still exempt from employee national insurance, but that is a change which will make those termination payments slightly more costly for employers. Okay, employment status then. My goodness, what would an update be without talking about employment status yet again? It's clearly something which doesn't seem to want to go away. So we do need to have a little look at where the case law has been across this last year. And actually, the cases are still following a very similar pattern as we've seen, which is, remember, this is all an issue about what is somebody's employment status. So are they genuinely a self-employed person, and in which case not entitled to holiday pay, sick pay, or any other protections? Or are they a worker and therefore entitled to the national minimum wage and holiday pay entitlements? Or on the other end of the scale, are they the gold-plated person, the employee with all of those particular employment rights? So the cases that we've been seeing tend to be where you have people in that gig economy looking to try to protect themselves and gain worker status so that they can have some protection of rights. Now, this particular case, a City Sprint case, comes on the back of City Sprint having been dragged through the tribunal previously with a large multi-party action to do with holiday pay, where people were trying to say that they were cycle couriers and actually they were workers rather than genuinely self-employed. So what City Sprint, in their wisdom, decided to do after those cases where they'd been found to need to pay holiday pay to people was to try to reinvent the terms and conditions that they entered into with their couriers, so that they could be more genuinely self-employed rather than deemed to be workers. So that's what they did. They tried to change their contractual terms and put those into play. And then, lo and behold, yet more cases are brought to try to determine whether those new terms and conditions that they tried so hard to put in place actually made any difference on the ground at all. And as you'll see here, in this particular case, the couriers were still held by a tribunal to be workers. So all of City Sprint's efforts were in vain, unfortunately. And actually what it all came down to was the fact that in some of the changes that they made, the tribunal felt that they had made changes to the practice on the ground of how those couriers actually operated. But one of the clauses that they tried to put into the contract was to say that people could send along a substitute. If they couldn't provide the service on an occasion, then they could send somebody else along. The courier could get a friend to do that shift for them, for example. what actually turned out to be the case was that nobody had ever really used that right of substitution that was in the contract, and therefore it was only ever really a theoretical right. So the tribunal found that actually it didn't have any practical effect. So those couriers were still deemed to be workers, which means they were still entitled to holiday pay. So City Sprint had gone through a lot of pain to end up exactly where they started. The Uber case, again, this is one that's been trotting through all the various courts for some time, and now we're still awaiting for the decision of the various Uber cases to do with employment status of their drivers. We're waiting for the decision to be promulgated by the Supreme Court. The case was heard, as you can see, back in July, but we're still waiting for that decision. And this is going to probably become the leading case. It will be the case that's gone right up to the Supreme Court. So it will be something that will be binding for the future and will set up the extent to which those contractual documents that an individual might enter into with a company are going to be binding. And it's all going to turn on whether something was actually happening in reality, even if it's set out in a document, just in the same way as the City Sprint case. Moving on then from employment status to look at employee data and monitoring, and a couple of cases that I just wanted to draw your attention to in this area. The first case is to do with covert monitoring. Now, this is a case that's originated from Spain, so it's Lopez, Ribalda and others against Spain. Now, the facts of this case are quite interesting, I think, and it was a case to do with a group of Spanish supermarket cashiers. This particular supermarket had been having significant problems with theft of their stock, to the extent that they were losing in some months 20,000 euros of stock. So they wanted to understand where it was going and where the thefts were occurring. So they did have CCTV cameras up in the supermarket with the usual signage so that members of the public would be aware that they were potentially being monitored. The issue arose because then the supermarket also wanted to put in place some covert recording. So they set up some cameras only for a limited period of time. It was actually only for, I think, for 10 days, but they put up some cameras which were actually focused on recording what the cashiers were doing at their tills. And it determined that actually some of the cashiers were indeed not scanning the products as they put them through, or they were involved in effectively a theft arrangement, and they were dismissed for gross misconduct on the basis of that covert data monitoring information that had been found. Now, rather than just going away with their tail between their legs, as you might have thought that those employees who'd been found to have been stealing should have done, they actually brought claims in the Spanish courts on the grounds of a breach of their human rights under the Article 8 of privacy. So they claimed that their right to respect for private and family life had been breached. And so this went all the way through the local Spanish courts, and actually they were found to have had their rights infringed by this covert monitoring. Spain then applied for a rehearing of that when it got to the European Court of Human Rights. They appealed through to the Grand Chamber, which sounds terribly grand, doesn't it? The Grand Chamber. And actually the Grand Chamber upheld the employer's appeal, which I think is good news, isn't it, for an employer, that actually they found there that those measures did not breach the right to privacy, that they were necessary and proportionate in the circumstances. Some of the key things to be aware of and takeaways if you ever are in the situation of thinking about covert monitoring is to take advice on it, because it is not an easy area. But what they found here was that the supermarket had tried very carefully to limit the number of people that ever saw the information that came from those cameras. So it was limited to the manager, to the trade union representative and to the company's legal representatives. Those are the only people who saw the data. And it was done for a limited period of time, and critically for the purposes of considering whether a criminal act had taken place. So it's not going to be a case that will always be followed, but I think it's one that's useful to know about. Then we have a case on vicarious liability. So whether an employer can be held to be liable for the breaches that the employee carries out. This is a case which, again, you might recall from previous updates. It was a case of Morrison's supermarkets against a variety of claimants. This was the situation, if you recall it, where an employee who is an internal auditor for Morrison's, he'd been disciplined, and basically he was really disgruntled about the disciplinary action that he'd suffered. So rather than just take it on the chin or resign if that was his decision, he decided to upload all the payroll data of the entire of Morrison's workforce onto a USB stick, and then he disclosed it all on a public file sharing website. Unsurprisingly, he was dismissed for that because Morrison's felt that that was really quite extreme vindictive behaviour. But of course then, and actually the former employee was found to have committed criminal offences. But Morrison's was held liable by all the various people who claimed that their data had been disseminated against their will, and they were held liable for that originally. The Supreme Court, fortunately, in a great result for employers, has found that Morrison's shouldn't have been held vicariously liable for that act, because what they've said was that actually, you know, they had put various measures in place to try to ensure that their data was looked after carefully. The fact that in this case, somebody had gone in a real vindictive course of action was that course of action was outside of the individual's normal course of employment, and therefore Morrison's shouldn't have been held liable for it, as the employee was effectively pursuing his own vendetta against the employer. Okay, so that's taken it outside of being within the course of normal employment. But that's always quite a fine balance, and as you can see, it's taken all the way to the Supreme Court to get a decision that's gone in the employer's favour for that one. Something else that I think is quite topical at the moment, hence why I wanted to draw your attention to it, is some guidelines that have come into place from the Department for Health and Social Care, DHSE, on workplace testing. Now, of course, we know, and a number of employers, I have queries from a number of employers who are wanting to put in place temperature checks or their own sorts of track and trace measures in order to try to protect their employees in the workplace. Now, of course, at the moment, for those of the people that are at home, it's perhaps less relevant. But I think the key here is to look at that guidance if it's something that is relevant for you, and to look at the sorts of things that are being found to be appropriate and those that are not. The key with all of this, of course, is communication with employees, to consult with staff if you are planning on putting any measures in place, and to make sure that everything that you do and any material and information that you then gather is collated and stored, if you're going to store anything, in compliance with GDPR. My advice would be not to store any of that data any more than you absolutely need to. So, for example, if you're doing temperature checks, of course, the temperature is registered, and then you simply don't record it anywhere at all. But do look at the guidance if that's something that's relevant for you. Sickness and disability. A few points just to raise on this. And this is really just to note, and again, of course, you might well have been grappling with this for some months now anyway, so it hopefully isn't news to you, but there were changes to the statutory sick pay regime in order to try to assist people who might otherwise not have been entitled to any pay at all due to the sort of definition, effectively, of incapacity under the existing statutory sick pay rules. So effectively, the basic situation with statutory sick pay is that to be eligible, you must be absent for incapacity. But of course, this is the curious situation that then arises that if an employee hasn't actually been diagnosed with COVID or exhibiting symptoms, then they're unlikely to meet the definition of the day of incapacity that you need to look at when you're looking at statutory sick pay. But you'll see that the changes that came in, I mean, the first one was on the 13th of March, and then there was subsequently lots of amendments to this and the changes to the regulations to try to keep up with the changing nature of the virus and the impact of it. But you'll see there the various purposes that are now deemed to be incapacity for statutory sick pay purposes. So it's shielding, although my slide says it's currently paused, the shielding regime, but actually new guidance has literally just come out on that, and I'm aware that the government has been sending out emails to those who were previously deemed to be clinically vulnerable. Literally today and yesterday, I know that individuals have been getting those emails where they are clinically vulnerable again, suggesting that they shield. So that is now back in force. And then, as you see, there's the list of those who will be deemed to be incapable and therefore entitled to SSP. And the other thing that's changed is that there's no waiting days for statutory sick pay. Of course, it used to be that there were 4 waiting days, qualifying days, before somebody would be entitled to pay. That has changed, so statutory sick pay can be claimed from the first day of absence if the employee is unable to work from home. Relevant to the various issues around people with illnesses at this period of time, but I thought it was useful to perhaps show you a couple of cases on the duty to make reasonable adjustments. And the facts with this particular one, Hill and Lloyds Bank, is that, and this is quite a concerning case, I think, for employers, so it's one to take note of, and it's all about whether or not something is a reasonable adjustment. In this particular case, the claimant had had a long period of absence for stress because she had said that she had been bullied or harassed by 2 colleagues at work. She'd raised a grievance about that. The grievance wasn't upheld against one of the colleagues, her line manager, but it was acknowledged that there was an issue in her ability to work alongside that manager. So she then sought assurances before she would return to work from her period of ill health. She said, look, I won't return unless you make these various reasonable adjustments for me. Firstly, that you confirm I will not. So you give me an undertaking, a very binding promise that I won't have to work with that particular colleague, the manager. And if you can't guarantee that you would then pay me a severance package. Okay, so quite unusual that the adjustment of not having to work alongside a colleague that someone's fallen out with isn't that unusual. It does come up from time to time, and it's something that is sometimes possible to achieve as an employer. But there's the second point that is the one that really stumped Lloyds Bank. They said, look, you know, we'll happily try to arrange everything so that you won't come into contact with the colleague who you've fallen out with. But we can't give you an undertaking about that because it might be that you do come across them. And they also went on to say that, look, this isn't going to be a redundancy situation. If you're not able to return to work because you can't work along, you don't want to work with that person, it wouldn't be redundancy. So we shan't be offering you any severance package as a result of it. It wouldn't be fair to other people. She brings her claim of discrimination, and actually in this particular case the tribunal, the Employment Appeal Tribunal, did hold that it was a failure to make reasonable adjustments on these 2 points. I think the other thing that's just you need to be aware of is that in this particular case the tribunal were using their power to make recommendations that the employer had to follow. So they actually recommended that this should be put in place and that it was something that they really, really needed to think about. And it went back to another tribunal to determine how that recommendation would work. But I think that's quite a concerning judgment. Just shows the extent to which the tribunal is prepared to intervene effectively and to make recommendations and to potentially order that severance payments are made in the event that an employer isn't able to guarantee what the individual felt was her safety. She was basically saying that she was put at a substantial disadvantage because of her anxiety, because the employer refused or wasn't able to give her those assurances. I think one point just to be aware of actually is that this is Lloyds Bank, a large employer. So they were deemed to have the ability perhaps by the tribunal to make additional steps beyond that which a smaller employer might be required to make. So that's worth mentioning as well, I think. Disability, another case on that, and this is to do with the definition of disability. When you're looking at whether or not someone is disabled and therefore whether they're able to bring a claim of disability discrimination, the first step is to identify, is there a disability? And this is what this particular Tesco's case and Tennant is all about. It's to do with whether or not that part of the definition of disability as to whether someone's condition, a physical or mental condition having a substantial adverse impact on someone's ability to carry out their normal day-to-day activities, has lasted or is likely to last for at least for a long time, and case law suggests that that should be around 12 months. So that's exactly, it's the long-term or otherwise nature of the claimant's illness that was at stake here in this particular case. The claimant had been off sick with depression from September of 2016. She brought claims for discrimination and harassment effectively a year later, and she was basing the claims on acts that she said took place between September 2016 and September 2017. Interestingly, she'd only gone off sick in September 2016, of course. So it was all about whether or not at the point that the acts of alleged harassment and discrimination took place, was she disabled? And because she'd only just gone off sick, the tribunal and the Employment Appeal Tribunal held that she wasn't disabled at the relevant time. So she hadn't been ill enough for long enough at the point that the alleged acts of discrimination took place. Now, the key here, and actually in my experience, it's not very difficult for a claimant to convince a tribunal that they are disabled. It's the test, it's there, but it isn't very hard to convince a tribunal of somebody's disability. And it's a point that isn't raised all that much, because most employers tend to then recognise, well, we'll accept there might be a disability, but we'll defend that we discriminated. So I think the key here is that this particular claimant did not show medical evidence. Had she done so, she might have been able to convince the Employment Appeal Tribunal that she was indeed suffering from a long-term condition. So I think the key here is just to be aware that it's all about the medical evidence. So if you are, if you're ever an employer in a situation where you're trying to say somebody isn't disabled, you will have to make sure that your medical evidence backs you up on that, because you won't get anywhere otherwise. Okay, now moving on, I'm afraid, to the not at all cheery but very, very pertinent topic of redundancy. There's a few points I just wanted to raise so that we, you know, there might be things that you need to come across. And again, it might well be that, of course, you're very familiar with this now and that you've sadly had to deal with it many times. But I just wanted to make the point that right when the furlough scheme first came out, there was some concern about whether or not it was possible to make employees redundant whilst they were still entitled to be on the furlough scheme, or whilst an employer was still furloughing them. We now know that, of course, employees can be made redundant on the furlough scheme. Had it not been for Rishi Sunak's recent announcements over the weekend and again today, actually this wouldn't be relevant for you, because the furlough scheme would have come to an end on the 31st of October. But it is still relevant because it is now still in place. So the key things, of course, when it comes to redundancy is to ensure that the proper consultation processes are being completed, being aware of the requirements. If there's a collective consultation situation, be very, very aware of the obligations that are on an employer to make sure they consult for the correct period of time, that no notices of termination can be given until that period of consultation has taken place appropriately. Interestingly, again, there was some real concern when the scheme first came in about what could be claimed under the coronavirus job retention scheme in terms of notice pay. An employer can claim for notice pay under the furlough scheme, but not the statutory redundancy pay. So and neither can it be pay in lieu of notice that's claimed. So if someone is working out their notice, they can still get their pay, or the employer can still use the furlough pay scheme for that period of worked out notice, albeit worked at home on furlough. But the notice pay must be increased. Where it's statutory notice, it must be increased to full pay. So whilst the government will pick up the tab for 80% of that employee's pay, they must be in receipt of full pay for that period of statutory notice. If there's any contractual notice over and above statutory, if it's at least 1 week more of contractual notice that's given beyond statutory, then all the employee will be entitled to for that enhanced period of contractual notice pay will be what they would otherwise have received for pay, which would be the furlough pay. So only 80%. So there's might be something to think about there. If you pay, if as an employer you have contractual pay which is over, or contractual notice rather, that's over statutory notice. As an interesting case, again, to draw to your attention, it's a case from last year, from November of last year, to do with redundancy and trial periods. And the facts of the case I don't really think are hugely relevant in some ways. It's simply that this particular employee, as a result of a reorganisation, was told that their role was to be deleted. That was the language that was used, classic NHS language for roles, and they were therefore put at risk of redundancy from the 3rd of July in the particular year 2017 that this case refers to. And on that same date, so the day they were put at risk, not terminated, their employment wasn't terminated, at that point they then started their trial period on a alternative role. And this case all turns on whether or not that was a proper statutory trial period or not, and therefore whether the employee ultimately, when they said that they didn't think the job was suitable for them, whether they should have been entitled to a redundancy payment. And actually, the point about whether they're entitled to a redundancy payment has been reverted to another tribunal to determine. But the Employment Appeal Tribunal looked closely at the point about whether or not they'd officially started on a statutory trial period or not. And they determined that the employer hadn't done things properly in that way, so there wasn't a proper statutory trial period. Now, the rules around statutory trial periods are pretty complicated. So, the thing to just bear in mind is, think about it. If you're ever going to be offering statutory trial periods, it is an entitlement. It's not something that you can take away. People are entitled to that offer. It comes under the Employment Rights Act that they have the entitlement to this trial period if you're planning on changing any particular terms of their job. So if the language from the Employment Rights Act is that if the capacity and the place where the employee was employed and any other terms and conditions of the new offer are different wholly or in part from the previous terms that they used to be on, then there is a trial period that their person is entitled to of up to 4 weeks. And that's got to be 4 calendar weeks that run consecutively. It can be extended. There is a possibility of extending that trial period, but only in limited circumstances. And it's all to do with retraining and genuine retraining. The key is that the employee must have been under dismissed or under notice effectively of redundancy in order for that trial period to kick in. Here, the employee had only been told that their role was at risk. So that's the difference. It's all about whether someone is actually under notice of dismissal that's relevant. Next case on redundancy selection. Again, I just think these are important points just to be aware of, given the number of redundancies that you may unfortunately be dealing with at the moment. So I think it is important to be aware of these sorts of cases and to know where to look if you are faced with this situation. This is all about the importance of choosing the right process to go through. So here, school was closing and actually reopening another school on the same site later on, but it was effectively the case that some claimants were being dismissed for redundancy. They unsuccessfully applied for jobs at this new site on a new school, but rather than being put through a selection process from within a pool for people who would be made redundant, they were actually asked to apply for these new terms at the new positions at the new school. So it was effectively, they were asked to go through an application process rather than a selection process from within a pool. Okay, so that's the distinction. And in this case, the tribunal held that that was unfair. Basically, they were effectively applying for their same jobs. They should have been selected from within a pool, and then the employer should have determined who to make redundant from that pool, rather than carry out that sort of more formal selection process where people have to apply for roles. That made these dismissals unfair. And in this particular case as well, they were also found to be unfair because these individuals were not offered a right of appeal. Now, note that in redundancy situations, there isn't actually a requirement under the ACAS Code of Practice to offer appeals against redundancies. But this was a case decided under Welsh education regulations, and there is a requirement for an appeal there. So it's a quirky one. Don't think when reading back on this case that actually you need to give right of appeal for everyone on redundancy. That's not a requirement.
Okay, that was all right. I like it.
Sorry, can we just make sure, please, everyone is on mute? Can please everyone make sure they're on mute? Thank you.
Thank you.
I don't know.
Okay. Next, then we're on to this subject. The coronavirus job retention scheme. And my goodness, I've had a day today in trying to keep up with where we're at. So let me take you through it. This is where the slides that you have in front of you may differ very slightly from mine, because I've tried to keep up with Rishi Sunak's announcements as the day's gone on. Okay, the furlough scheme, the coronavirus job retention scheme, was of course due to end on the 31st of October. At the weekend, when we had the announcement about the lockdown that we're currently in, the scheme was extended for a further month. So it was meant to end in December. However, today, the Chancellor has announced that the scheme is now going to remain open until March. So it is now open till March. That's the difference that you'll see in your slide. So that's a change. It is not ending in December. It's staying until March next year. Now, who knows whether it will then be extended again? We do not know, of course, what the situation will be at that point in time, but this is where we're at today. So the scheme is effectively going back to how it was in August of this year. So that's where employers can claim up to 80% of an employee's wages, up to that cap of £2,500 for hours that somebody does not work. So if they're furloughed, it's 80%. It is, as I say, it's back to how it was in August. So it is the case that an employer will need to pay national insurance contributions and pension contributions on top of that 80%. And we are still now in that situation where both flexible and full furlough, so that means part-time or full-time furlough, is going to be permitted. The guidance on this has literally just been published today as well, but there's going to be full guidance. There's only limited guidance, and the full guidance is due to come out on the 10th of November. So we'll wait to see what the full guidance is on this. A couple of other points. The employer, so an employer does not have to have used the furlough scheme before. So it could be the case that an employer didn't have to rely on it previously, but is now in the position where financially they would like to use the scheme. It is going to be available for them. But and employees don't have to have been furloughed before either. So this isn't the case as it was for a period of time where only employees who were furloughed in the first tranche, as it were, could be furloughed again. Now it's open again, so long as the employee has been on PAYE payroll on the 30th of October. Okay, so if they're on the payroll then they can take advantage of the furlough scheme again. So that's the hot off the press position. Now, just a couple of points as well, just to be aware of. This is a scheme which, of course, came in such a hurry, has been an amazing benefit for lots and lots of people, but has also been subject to fraud, as one might sadly imagine. So HMRC are issuing what they call nudge letters to employers that it thinks might have overclaimed during this scheme. And actually we had the first publicised arrest in July of this year of a man in the West Midlands who was suspected to have defrauded HMRC of £495,000 under the furlough scheme. There's an estimate that 5 to 10% of the cash might have been wrongly awarded under the furlough arrangements. So there is quite a substantial desire on part of HMRC to try to recoup that money, of course. And they have got power to do that. So that's just simply a warning. At its peak in August, of course, 9.6 million people were on furlough. And who knows now what the position is going to be as we move forwards. But just be aware that obviously claiming under that scheme needs to be done carefully, because HMRC can go back and check it out. Again, stop press, something that's come about just today again as part of the Chancellor's announcement in the House of Commons today. The job retention bonus that was supposed to be offering £1,000 for employers for each employee that they'd had on the furlough scheme if they remained employed by the 31st of January next year was due to come in place. It's been scrapped, so it's no longer a thing. The bonus is being scrapped because, of course, the furlough scheme is going to continue into March. Holiday pay and furlough. Now, again, I only raise this just as a reminder to you, because I would imagine that if you have been involved in dealing with anybody who is on furlough in your employment, then you might also have had to deal with the issue of holiday. But it's just a reminder that despite the uncertainty at the beginning, when the furlough scheme first came into play, and there was some concerns about whether or not somebody could accrue holiday or could take holiday during furlough, is possible, of course, to continue to accrue holiday during periods of furlough. That has been clarified, and that's all to do with the statutory holiday, so working time holiday. Contractual holiday might depend on any terms of a contract. So if you've set out some terms of a furlough agreement separately, then that goes for the holiday that's above and beyond statutory entitlement, then you might be able to make a difference there. Hope you're not troubled by the fireworks all going off in the background. Hope you're disturbed by those. So I think that hopefully everyone is aware of the fact that furlough is continuing, and holiday can be taken during furlough as well. There was a big query about that, and a query about how it would all work. The other thing is to be aware that if somebody who's taking holiday should have their pay topped up to their full rate of pay, rather than just being paid furlough pay for any periods of holiday. And further on holiday, the subject of holiday, an amendment was made to the working time regulations to allow for carryover of holiday during this period as well. Now, of course, normally under the working time regulations, there is a limit on the amount of holiday that can be carried over. But now there is 4 weeks statutory holiday pay, so an increase on the amount of holiday that can be carried over, really to recognise the fact that if employees didn't want to take any of that holiday, then they could carry it over for a period of 2 years, if it wasn't reasonably practicable for them to take it in this current leave year. Now, the guidance really, and my suggestion if you're working for an employer, is to try to ensure that employees do take holiday, because otherwise an employer is going to be left with quite a difficult year in the future, when they will have people taking large amounts of holiday at a time when they might really, a company might be wanting to get back up to speed and actually have everybody working. So encouraging people to take their holiday, even if they're on furlough leave, would be an appropriate thing to do. Not least as well, because actually people need that rest. Furlough isn't necessarily the same as rest, and so it's appropriate to encourage people to take that. And also don't forget that, of course, if somebody leaves employment, their employment terminated, they would be entitled to be paid in lieu of any accrued but untaken holiday. So if they've carried over a large amount of holiday, there's going to be an increased requirement to pay for that holiday on that termination. So again, a potential cost for the employer that you might want to avoid. Again, I was going to talk to you about the job support scheme that was announced, that was going to take effect from the 1st of November, and then was going to be delayed a little bit. But again, I'm not going to go into any detail about it, because I simply think it's been withdrawn at the moment. It's all off in light of the furlough scheme being extended. And really, I think that the guidance that was issued has been withdrawn as well. There's really no point us going into detail, because, my goodness, who knows what might need to be put in place after the furlough scheme in March. So we will have to just wait and see for bulletins and announcements from that point on. So that brings to an end my missive on furlough and all of the announcements and things today. But I do then want to talk about the other rather large issue, which affects some of you perhaps, but not all. I acknowledge that, but it's to do with the cap on public sector exit pay. Now, again, this is something that for those of you that were at this session in previous years, you will have heard me talking about this cap, which was first proposed in 2015. So actually, it was probably the first of my sessions that I held when I might have mentioned it first time round. It is now in force. So there is a cap now that came out originally from the Conservative Party's manifesto pledge back in 2015 to end what they saw as six-figure payoffs, the fat cat payouts as they announced them at the time. And it's taken all this time to get this in force. Now, as I say, in force from the 4th of November, and I'll go on to just set out and just leave you with the slides as well of the actual detail of that cap. But there has been detailed guidance of that published just on the 29th of October. So again, very, very topical, and a Treasury direction on it. So if it's relevant to you, it's very worth looking at that guidance. It has been subject to lots of controversy. The British Medical Association has actually applied for a judicial review of this cap because they are concerned about the difficulty is that this cap is effectively coming in to prevent people in the public sector receiving high payouts on the termination of their employment. The difficulty is that those payouts might be something they're contractually entitled to. So you have a situation where on one hand, the employer cannot pay what somebody is contractually entitled to because of this cap. And that's what the British Medical Association is particularly concerned about for its consultants and highly paid doctors. Now, here are the various points on the cap. And again, in the interest of time, I'm not going to take you through all of these in huge detail, but they're there for you. So it's a cap of £95,000, pretty much to all of the public sector other than the armed forces, really. And it really is designed to capture pretty much the majority of payments that might come into play on the exit of an employee. So these are the payments that would be captured. Redundancy, you'll notice there, and critically, and the most controversy is around the pension strain payments. So these are payments where somebody might be able to have their pension increased if they're leaving for early retirement reasons, so they're leaving early, and they would therefore take a reduced pension. There are certain times where somebody would be entitled to have a chunk of money put into their pension scheme so that they had effectively an unabated pension as though they had retired at the normal retirement age. That's a pension strain payment. Those are significant payments, and actually often impact lower paid employees who are long-serving public servants rather than just these fat cats that this was all designed to capture. The point as well to note is that there's a broad category of all of these things that are captured, these termination payments that are captured by this cap. Notably, settlement payments are captured. So if you wanted to make a settlement, and of course that's very often how these payments are made, is as part of a settlement agreement or some other conciliated payment through ACAS or in any other way up to the door of a tribunal. These will all now be caught by this cap of £95,000. Now that only leads me to think that employees are going to be incentivised actually not to settle claims, but to carry on and bring their claims fully in the employment tribunal, because claims that have the orders of compensation made by a tribunal are not caught by this cap. Okay. So that's where you come on, and those are the points where things that are not included in that cap are set out on that slide. And as you'll see, the last of those sub-bullet points is payments that are awarded by a court or a tribunal. So it really does appear that people will be far more encouraged to continue with their claims right the way through to a hearing rather than look at settlements, because they'll be able to get perhaps way above that cap. There is the opportunity to relax the cap in certain circumstances, but the public sector is going to have to be very careful about when they waive the cap, and they will have to get Treasury approval or a full council approval to do that. There are occasions where the cap won't apply, so that's in discrimination claims as an absolute waiver, whistleblowing matters and health and safety related matters. So settlements could be carried out in those particular claims. as I said, I've said that pension payments are included in that cap, and that's why there is a concern that it is going to impact those middle earners rather than always the higher earners. And actually, there is a discrepancy with what's going on, because the government's brought this into effect on the 4th of November, as I say, so as yesterday. But actually, there's a consultation which is still ongoing in relation to how to amend pension schemes so that people might not be entitled to these increased pension strain payments. And the consultation on that doesn't actually close until the 9th of November, so next Monday. So there's a discrepancy in the time here, which is going to potentially cause some significant problems. Tribunal rules of procedure then, just a few points here to flag to you as we're really coming towards the end of our session. As you will not be surprised to hear, there is an extremely large backlog of cases in the tribunal system now. There already was, and then we were faced with COVID, so the tribunal is in a real pickle, to put it politely. There's been an increase in single claims of up to 18% compared with this time last year. And the backlog of cases is at a 10-year high. As you'll see, 45,000 cases of backlog in August this year, up by 26%. So, my goodness, it's a tricky situation that the tribunal finds itself in. Therefore, to try to address that, they've put into place some amendments to tribunal rules so that hearings can take place remotely, and there's a variety of other changes that have taken effect from October to try to assist with this backlog and to try to increase the capacity for the tribunal to get through these cases. Here are some of the things that have been put into play. And it's interesting because, of course, whilst we want to get through the backlog, it's really important that cases are dealt with properly and fairly and in accordance with the law. What we're seeing now is that there's going to be the ability for non-employment judges, so legal officers, to make some of these decisions on cases and to hear some claims. Now, you know, that is a bit of a concern, I would suggest. I think it's really helpful that legal officers can make some of the case management decisions. So things like applications to extend time for filing a response, for example, or applications to extend different orders or change orders, just case management stuff. That's great that a legal officer can do that rather than it having to go in front of a judge, because that just slows the whole system up. But on the flip side, I do think that we need to be sure that the people who are hearing the claims are hearing them appropriately, I think. As I say, there is now facilitation for remote hearings, so there's all sorts of processes about making things as easy as possible to do hearings like this virtually. And if those hearings need to be carried out face-to-face, again, there's been a variety of rules and regulations taking place around what to do with paper, you know, the safety side of things. So again, I don't think that there's any point in me taking you through all of those particularly, but just be aware there are changes to try to address this backlog. One of the things that's might be quite interesting for you to be aware of as well, another change to the rules of procedure, the third bullet point down there on that slide, that cases, normally when a case is dismissed because one of the parties has withdrawn, so in other words, a case is settled, that case would still be noted on the public register. So somebody could search for claims and find you as the employer has been in front of a tribunal, albeit a case is settled. Actually now, those cases, if they're settled, are not going to appear on the public register anymore, which from a reputational damage point of view might be relevant. And also the conciliation period for early conciliation through ACAS is to be increased from the 1st of December from 1 month to 6 weeks. Now, it was already possible for conciliation to be extended if the conciliator felt that a settlement was imminent. But this is interesting that it's actually officially being extended now to 6 weeks, with an aim, of course, to try to get more cases settled, so less have to go to the tribunal and less therefore clog up the system even more. Finally, a couple of cases just to draw your attention to on disciplinary issues that have come about in this last year that I thought were useful. One particular one was a particular case about how much knowledge the employer is deemed to have, okay? Now, this was a case with somebody dismissed because, well, it was alleged, he alleged that he was dismissed because of his trade union activities. He was dismissed, note that, for being 1 minute late for a scheduled job. Now, fine, that's good time, you know, amazing timekeeping that employer obviously required. So it seemed to be a very punitive sanction for a relatively minor act of misconduct. So that's why the tribunal was particularly looking to see what was the real reason here for this person being dismissed. Was it the fact that they were late for a particular job, or was it something else? And the employee said it was something else. They said, I was automatically unfairly dismissed here because I was dismissed actually because of my trade union activities. I was a health and safety rep and they didn't like, he didn't like me. And in this particular case, even though the disciplining manager and the appeals manager wasn't motivated by that trade union activity, it was found by the EAT that the decision had been manipulated by the senior manager who carried out the investigation, or took a leading role in that investigation at least, and he was the one that had a grudge against the employee. And in this case, you know, they felt that the tribunal felt the investigation had been wholly inadequate, and really it was clear that the driving force behind the dismissal was that senior manager, so that there had been a significant influence of his behaviour on the person who ultimately carried out the dismissal and the appeal. So it's worth noting that, you know, it's not just what the dismissing officer or the appeal officer thought, but if actually the underlying investigation or there's somebody in the background causing that decision to dismiss, you know, and that's what will be looked at by a tribunal as well, as shown by this particular case. And then another case on knowledge. Again, what did the employer know when dismissing? In this particular case, the investigator, again, this falls on the investigator, which is interesting. It's a case from the London Borough of Ealing. The claimant was accused of a sexual assault and was dismissed for gross misconduct. As you'll see there, the investigating officer knew that the complaint had been withdrawn from the police complaint had been withdrawn. But crucially, they didn't go on to inform the disciplining manager. So the dismissal carried on, even though there were facts that were really critical that hadn't been passed on. And in this particular case, the principle of duty, that particular case reference that's there, that was a case that you might have heard of, and it was all to do with, well, what was the true reason for the dismissal. And actually, if the true reason for the dismissal was hidden from the actual person who decided the case, then it's still going to be the employer liable for whatever that real reason under the surface was, just like I've shown you in that previous case. You know, so just what the dismissing officer knew isn't necessarily the whole picture. Here, it will be about the whole process that's been followed by the employer, and here the investigator knew something. They should have passed that information on. The employer was deemed to know it, even though the actual person who carried out the dismissal didn't know it. So what do we learn from those couple of decisions? You know, I think that the tribunal is always likely to attribute knowledge for the dismissing officer to the whole employer. So the employer will be liable if it's been at all influenced by the decision, influenced by anything that's gone on in the past, even if it wasn't in the mind of the person who actually made the decision to dismiss. So that's quite tricky, isn't it? It really then makes that investigation very important. It makes the transparency of that investigation really important. And the fact that an investigation should really be carried out by somebody who is skilled and knowledgeable about how to do investigations really well. Okay. My last case for you, you might be pleased to hear, is to do with process. And what would be an employment law update if we didn't finish with something to do with procedure? And this is a case which, my goodness, this is a real surprising one. So it will make you sit up perhaps and take notice at the end. In this particular case, somebody was dismissed without having any process applied. And it was found to be fair, would you believe? So this, but please note the caution that I put at the bottom of this slide. this is a rare case. So I wanted to draw it to your attention because in rare situations, having taken advice, it might be useful for an employer, but it is not one to use in a cavalier fashion. Here, the facts of the case, a senior manager notably, was dismissed at an appraisal meeting. Basically, all trust and confidence had broken down between that senior manager and their manager. So we're at a very senior level of the business here. They felt that the trust and confidence had completely gone, the relationship had broken down. So the employer decided that they would dismiss and use that reason for dismissal of some other substantial reason, SOSR. Now, normally in an SOSR dismissal, there is still an obligation to try to look at whether a process should be followed in bringing about that dismissal. But here, the employer was able to convince the tribunal that actually everything had broken down to such an extent that really any process would have been completely futile. And in fact, they also convinced the tribunal that the individual was showing no inclination to try to resolve matters or to try to sort of mend the situation with the employer at all. So the trust and confidence had completely gone, process would have been futile, and here the decision was found to be fair despite the lack of process. So I thought you'd find that one interesting, but please tread cautiously in following it in any situation. That brings an end to everything I wanted to cover for you. I know that's a huge amount, so thank you very much for I hope you're listening in the background. All I can see is a sea of black little squares, but I hope you found that useful, and I'm very happy to take questions. Okay, hopefully you
Sonia,
can collate
thank you
if there are any.
so much. Thank you so much. A whistle tour of so much information, but incredibly useful. And you probably won't be surprised to hear that most of the questions this evening relate to the furlough situation. But to start us off, I have a question here, which, oh, my chat box has just disappeared. I have recently started work for a haulage firm. They charge drivers 50% for any penalty notices, but I read that you can't do this unless people have agreed in writing that this can occur. Is this correct?
Okay, so that sounds as though it's to do with making deductions from somebody's wages for if they've got a speeding ticket. Is that the sort of thing that we're thinking about? If that's what it is, I'll assume it is, but yeah, I mean, the normal position is to make a deduction from somebody's wages, you need to have a contractual entitlement to do that. So you would expect to see something in somebody's contract saying if you are found to have, or if you've had a penalty notice put on you, you've speeded or whatever it might be, then the company is entitled to recover some of that money from your wages. In the absence of that, I think it potentially, again, depends on all the circumstances, but could be an unlawful deduction from wages.
Thank you. Next question. If an employee was on furlough and now is on garden leave, can furlough still be claimed?
Garden leave is effectively somebody serving their notice whilst they are sitting at home. So yes, it is still effectively a period of notice. I don't see any reason why furlough couldn't be used for that period of time, because it's still notice. It's not being paid in lieu of notice. Garden leave is someone still remaining employed, but simply not carrying out any work. So yeah, furlough could apply.
Thank you. If we have employees who have been on furlough since March and they're not likely to be back to work anytime soon, they've had letters with no end date and they've consented, would we need to reissue letters or can we still rely on the original letter?
This is something, this is something that we've been debating in the office over the last few days for a number of clients. I would suggest best practice is to actually contact your employees again and just to reiterate the extension of the furlough scheme, not least from an employee relations point of view, because it seems to me that employees might well be sitting at home rather worried and unsure about what's going on. So a communication, if you haven't had one informally, a formal letter since March, I think that another one would be sensible. Do you have to? Probably not. But, you know, I think that it seems to me to be a sensible thing to be writing to everybody again, just to touch base with them, to explain the situation, and to confirm that you intend to keep them furloughed, and to get their consent to that.
Okay, thank you, Sonia. If you've not previously been furloughed, but you've had a temporary reduction in hours, so for example, 5 days down to 4, can we revert back to 5 days and then use the flexi furlough?
Yes, I think in short, yes. I think that it's open. It's open. You don't have to, it's been quite clearly set out that so long as somebody was employed on that date of the 30th of October, I think I'm right. So long as someone was employed on that date, let me just double check the dates. Sorry, with everything changing. Yes, 30th of October this year, so long as they were on the payroll on that date, then, you know, even if they'd not been furloughed before, they're entitled to be. So it seems to me that you could put them back onto their full pay rate and then use the furlough scheme in a flexible way if that was appropriate for you. Yeah.
Okay, thank you. Will furlough stay in place for shielding until the end of March as well? Just wondering if the furlough agreement should state March as the end date, or December and then review?
Well, the furlough scheme has now been extended to March as of today, so I would suggest you put in that March date. It seems to me there's nothing now that says December at all about any of it.
Okay, well,
from a furlough perspective.
Sure. What is the 7 consecutive days referred to under the new furlough? Is this purely to do with the payroll reclaim from the government, or do employees have to actually be furloughed or flexi furloughed for 7 consecutive days in a month?
It's about if I'm reading that question or listening to that question correctly, it's the aim of the scheme when it first came out. What the government didn't want was for people to be hopping on and off of furlough, having a day furlough, a day back at work, a day of furlough, because it would have been impossible to administer the payments for that. So the requirement is for somebody to be furloughed for at least 7 consecutive days. They could then be brought back to work for another period of however long, a week, a day, or whatever, but then they would have to have another period of at least 7 days off before a furlough to enable to claim that money. So it is a 7 days of furlough at a time that needs to be carried out.
Thanks, Sonia. I think that this next point, I think that you've just covered it, but just to reiterate, read the extension of furlough. Is it seamless? Does it cover the whole of November, or only from today, the start of lockdown?
It's seamless. It's seamless. That's my understanding of it.
Yeah.
I have to say a bit of hesitation in my voice, but yes, no, it was due to take place through to the 31st of October. It's been announced at the weekend that it would be extended. My understanding is it's entirely seamless.
Yes, that was my understanding too.
Yeah.
We haven't used furlough. Do we still have to allow the increased carry forward of holidays if our employees have all been working normally? And there's a few questions here actually about holiday entitlement, and I know that you covered this, Sonia, but it might just be worth just reiterating the entitlement and the situation for employers.
The amendment to enable carry over of additional holiday was under the working time regulations, and so my understanding of that is that it applies whether or not somebody has taken any period of furlough. It seems to me that the wording in the amendment to the working time regulations talks about whether somebody has been prevented from taking their holiday because of coronavirus. Now that doesn't say taking their holiday because of furlough. So I think that any employee who has or hasn't taken a period of furlough leave is entitled to carry over holiday that they haven't been able to use this year. And my guess is that extension, which was only intended to be for 2020, I would have thought, is going to be brought through into 2021 as well. So I expect that, the danger is you could have, it come 2022, you could have employees who haven't taken any holiday and have rolled it over, and you could have 8 weeks of rolled over holiday to deal with. So I think the main point there is to try to encourage employees to take their holiday come what may, and not to really carry lots of it forwards. So encourage that time off where the business needs allow.
And just related to that point of holidays, should the bank holidays have been topped up if not normally worked whilst on furlough?
Yes.
Okay.
Yes.
Thank you. This is a question from an HR consultant who's recently opened her own business. At present, she says, I only have 2 clients and I am the only employee in my new limited company. Therefore, I will not have any resources to provide a replacement person to support my clients. I'm concerned about the effect of IR35 on my business. How are the new rules likely to affect someone in my position?
New rules on IR35? That's one question. I'm very happy to take most of these questions, but IR35 is so complicated. I have to say that's something that I'm very happy to pick it up after the event, but it's one area that the rules are in flux because they're due to come into force with changed rules in April next year as well. So it is an area where I wouldn't feel very comfortable just giving an ad hoc piece of advice on that particular point, I'm afraid. Sorry.
No problem. Thank you. Isn't a question, what is your view on putting, oh, sorry, I've just flipped to a different question. Sorry, I lost that one. Come back to that in a minute. What is your view on putting an employee made redundant back on furlough?
It depends whether their employment has actually come to an end or not. Because if they have been made redundant, then they are redundant. They are no longer your employee. Therefore, they wouldn't be an employee on your payroll as at the 30th of October, and so therefore wouldn't be entitled to furlough pay. So it all turns on whether or not somebody is still your employee, albeit under notice of redundancy. If they are, you could remove the notice of redundancy. You could withdraw it if the individual accepts that. They, of course, might prefer to take their redundancy payment. Depends on the circumstances. In theory, though, if they're accepting of coming back, or if they're accepting of you withdrawing their notice of termination and they're still therefore an employee as at the 30th of October, in theory, then they could be furloughed. Yeah. I think that was one of the points that the government has taken real criticism for, of course, by in some people's view, being slow to announce an extension to the furlough scheme, because it has meant that lots of employers had taken steps to terminate employment of lots of people on the grounds of redundancy because they were anticipating the end of the furlough scheme. Now, of course, that the situation that delegate's question, is exactly the situation that so many employers are in that they have made people redundant who they might have been able to keep on the furlough scheme had they known it was going to be carrying on.
Thank you, Sonia. I'm just going through all of the comments here, and so many people are thanking you for all of your hard work and keeping up to date, and for a really informative presentation this morning. So that, really appreciate you giving us the time this evening, and for, I know you've worked really hard to make sure that this is so relevant to everyone. So yeah, lots of messages of appreciation, which I just wanted to share with you there. We've got a few new questions just coming in now. Let me just go to the. So I'm receiving lots of messages by private message and everyone chat here. So did we just make sure that I'm responding as far as we can to the messages coming in. Okay, look, thank you for all of your appreciative messages. It's really good to get feedback. In fact, if you have a look in the chat box, I have included a link to feedback, which we always really appreciate feedback. So if you could give us complete the form and get us your comments, then that would be much appreciated. And another question here: are 0 hours employees entitled to be furloughed?
If they're employees, yes. The difficulty is about the calculation of what their pay will be, but there are detailed guidance notes available on how you calculate furlough pay. But yeah, I mean, as long as they're an employee, then they are entitled to that claim.
Fantastic. Okay. I think most of these questions now have been, we've tackled most of them across all of the various subjects of redundancy and furlough and holiday and furlough. Let me just, a couple of messages coming in. Please can you confirm the date that the furlough will start? As I thought it was the date of an HMRC RTI input. I think I've read that. It's jumping around. Sorry, all these messages coming into me.
I'm not sure I fully understand.
No, I think that might link back to the other question, which I think you responded to, about the seamless.
Yeah, continuation of the scheme.
Continuation, yes, yes.
Now, I mean, I would caveat all of this. Of course, this is my understanding of all the issues subject to the changes that have been going on. So if I've been incorrect on any of the dates and details there, then of course I really apologise, but it's a case of trying to understand the rules as they come out minute by minute. So I'm pretty sure I'm right on that, but as I say, it may be that the guidance is slightly different.
No need to apologise at all, Sonia. We really appreciate your help. I think mostly that's all of the questions now. So you know, huge appreciation for your time and your effort today, Sonia, in putting together the presentation, the session, and making sure that we're all now as up to date as we can possibly be in the circumstances. Thank you so much. And to thank you to you all for attending this evening. I've put a link in the chat box, as I say, to a feedback form. So we really appreciate your feedback. And I've also put a link in the chat box to further events that the Essex and Ipswich CRPD branch are running. So do have a look at that link. Some great sessions planned for the coming months. And we look forward to seeing you there. But let me just finally say huge thanks to Sonia for this evening. Really good to see you. And hopefully see you again next year, Sonia.
Well, thank you so much. And stay safe, everybody. It's really nice to have had you listening. Thank you.
Thank you. Yeah, just to let you know then that the slides, the updated slides, will be made available to you, will be sent to you following this event, along with the recording of the session. So if you didn't manage to write all of your notes in response to what Sonia was talking us through, then there'll be another chance for you to review that going forward. Many thanks, everyone. Have a good evening. Bye-bye.
Good.
I just removed
Just
everybody
us.
who was left.
Thank you, Sonia. That was excellent. And you know, the comments are really, really appreciative. That's fantastic. So
I just hope that I've got some of those finer details. I think on some of the dates on the furlough, I'm pretty sure I'm right, but I hope I haven't misled anything. You know, if I check it out tomorrow and I think there's anything wrong, I'll obviously make that clear in when I send the slides through as well. But
it might have all changed by tomorrow.
Well, you know, this is the thing, isn't it? All right.
Yes.
Good.
Yes.
Well,
Really
thank you.
appreciate it.
No, pleasure.
Sonia.
Thanks for the opportunity. Enjoy a glass of wine now, as I will. And
oh, absolutely do. Yeah. Thank
and
you.
really nice to meet you both and see you, Jackie, as well.
And you, yes. Okay,
Thank
thank
you
you.
so much.
See you.
Thank you.
Bye. Thanks, Jackie.
Thank you, Kay. Yes, amazing and amazing timing.
No, nothing worse than overrunning, is there?
No, absolutely. But that was fabulous.
No, good. Well, that's one down, and I think we've got one more to go for me, and lots more to go for you.
Yes. Well, it's a team effort, isn't it? But really,
Yeah.
really appreciate that, and you know, for your first event to have 100 people in the room, amazing. Thank you.
Yes, that was really good, and lovely to recognise some of the names as well. I think the only thing is, I'm on this tiny little because I've got an office which I go to work each day, and I wanted to come home to see the children before I did this, and so I'm on this tiny laptop which I'm not used to, and this the little mouse in the middle which you have to use and to find the chat box. I'm like, oh my goodness, I can't read all of this. It's always, you know, when you're not familiar with something, it's really, really challenging. Still, no, have a lovely evening. Have a glass of wine now. Enjoy your husband's birthday.
Yes, thank you very much indeed. Thank you.
Okay, we'll see you again.
All right, take care, Kay.
Take care. Bye-bye.
Bye.